but hopefully that won't be the case for our first speaker, John Buchanan. John is an accomplished lawyer at the Covington firm, a graduate of Princeton, Oxford, and the Harvard Law School. But my particular contribution to the introduction note, what a tremendous asset he's been to the American Law Institute Restatement of the Law of Liability Insurance Project, where he was an advisor, and I got to see firsthand his deep expertise and the respect he enjoys throughout the profession. He represents policyholders, and today we'll be talking about liability for artificial intelligence. What is the current insurance cover situation in the United States? And so with that, I'll turn it over to John.
Thank you, Jeff. Can everyone hear me?
Yes.
I am, I hope, sharing my screen, but I'm getting an echo. My apologies. Can everybody see that now? Thank you, Jeff, for the introduction. I must say that those American Law Institute meetings were always much more fun when Jeff was there. Really appreciated having him there. I will start with a basic vocabulary lesson, so we're all on the same page. Artificial intelligence has been defined as the capability of a machine to imitate intelligent human behavior, but that covers a broad spectrum, ranging from what they call artificial narrow intelligence, which is really very simple if-then types of algorithms, up to what they call general artificial intelligence, which one writer characterizes as our future robot overlords. And many of the litigation cases so far, at least in the insurance realm, tend to have involved the narrower types of and simpler types of artificial intelligence. But a critical part of the broader, more general types of artificial intelligence is machine learning, where the system learns automatically, improves from experience, and doesn't have specific human programming input. And then robotics is where this computer coding intersects with physical machines, which we call robots, or driverless cars, autonomous vehicles, et cetera, et cetera. Now, machine learning seems rather exotic, but there are various steps that all involve human input. There's a fundamental objective, the business model, that has to be decided on. The training data set for the AI needs to be selected. The model, the algorithms that detect or predict from patterns in that data training set have to be devised. And then it has to be trained. Machine learning really involves machine teaching. And in my mind, the most appropriate metaphor for machine learning AI is the clueless human teenage adolescent. who requires teaching supervision by human beings, and hopefully by responsible adult human beings. So the bottom line lesson there was well stated by Professor Fei Li. There's nothing artificial about AI. It's inspired by people, created by people, it affects people. So some of the applications of AI and robotics, there's a multitude of them. Most of us encounter on an almost daily basis the CAPTCHAs that introduce websites. InsurTech, if there's time at the end, I'll be talking about some of the litigation that's arisen from the use of AI in underwriting and claims evaluation. Drones are another example. Autonomous vehicles, aka driverless cars. They're not as far along as we're predicting just a few years ago. But in a more controlled setting, you do have autonomous vehicles in manufacturing or industrial or warehouse settings. Here's a robot warehouse tractor that is made in my hometown of Pittsburgh. The head of that firm assures me that they have a perfect safety record thus far. So you can see the human being in the background there. And perhaps you can discern the human tractor driver behind the robot tractor. And I would guess that the pedestrian there is far more at risk from the human tractor driver than the robot. So that's a useful application of robotic technology. The other, it goes on and on. One of the ones that we just came across, one of the applications we just came across that illustrates the diversity, if not the frivolity of AI applications, is an advertisement for mascara that is purportedly the product of a machine learning artificial intelligence algorithm. And the applications go on and on. Healthcare is a great application. The pandemic has spawned new potential applications. Tracking coronavirus and another pandemic-related phenomenon, the supply chain backup, AI solutions to manage and alleviate that strain on the supply chain have been devised. You do have to think about the catastrophic disruption that could result if AI that's intended to manage the world's supply chain went wrong in some fashion. Which brings me to my next topic, which is what can possibly...
Apologies to everybody. Jeff, if you agree, you're the master of the ceremony.
I yield to you, and thank you for that intervention. I was unsure what to do. If you would go ahead and introduce Professor FAURE, maybe we would take his segment now and then return to John after his problem's resolved.
Gladly so. Well, apologies to everybody, but the speeches we have prepared for today are rather independent of each other, and so I don't think the change in order will have any impact on the overall event. And I'm very, very glad and happy to introduce to you Professor Michael FAURE, who is an eminent European legal scholar. He is the director of the Maastricht European Institute for Transnational Legal Research. And at the same time, he has a half-time professorship at the University of Rotterdam, the Erasmus School of Law in Rotterdam, where he is also the director of the Rotterdam Institute of Law and Economics and of the European Doctorate in Law and Economics. I've repeated now economic analysis, law and economics twice. This is definitely a focus of his research work, by far not the only one, but a very important one. And concerning the topic you will talk about today, most importantly, I can refer to your previous works on law and economics and compulsory insurance, and you will present your ideas on compulsory insurance with a view to artificial intelligence today. Thank you very much, Mr. FAURE, to be with us, and the floor is yours.
Thank you very much, my dear colleague, for this nice introduction. And indeed, I think, dear colleagues, that this is a fascinating topic. Now, why talk about the topic of artificial intelligence and compulsory insurance? Because we know John, a few minutes ago, was talking about the US. I think some other speakers will talk about the fact that now at the EU level, a lot is going on. There are all kinds of expert groups, there are white papers, there are proposals of the European Parliament, and there is almost, as some people say, a race for more regulation. And in one of those documents concerning regulation, we saw something very surprising. Helmut pointed me to that at some moment. There is a small little sentence that says that the front-end operator of a high-risk artificial insurance system shall ensure that operations of that system are covered by liability insurance. And it continues, and so there is the idea of the European Parliament in this resolution, in this proposal, that there should be mandatory insurance, compulsory insurance for artificial intelligence. Now, I have to admit to you, I do not know that much of artificial intelligence. There you really need to wait for John, who is the expert in that domain. But I know a little bit, as Helmut was saying in the introduction, of the law and economics of insurance. And let me say, from that background, I found what I saw there to propose mandatory insurance for AI. I found that interesting, to put it a bit in that sense, interesting in the sense of strange. What I would like to do with you is very simply go back to the basics and ask ourselves, okay, what would be the function of financial security in the domain of artificial intelligence? Why would an individual want financial security from the individual's perspective? And what may be arguments why society would say, we want financial security so much that we would like to make it compulsory, mandatory? And under what type of conditions would that be a good idea? That is what I would like to do in the 18 minutes that are left to me. Now, obviously, in order to know whether you would like, let's say, mandatory insurance, the last time Helmut and I were together on the seminar, Helmut said a very wise point. And his point was that, of course, when you talk about liability insurance, there is always a rule in insurance that liability follows insurance, so to say, or if you want, insurance follows liability. What do we mean with that? That the two, of course, are connected. In the sense, if you want to know whether there should be a financial security, you first want to know whether there is a liability for a particular activity. But you know, for now, I'm not going to dwell, otherwise I would need all my 17 minutes just to talk about what are all the liability constructs. I'm immediately going to jump in the water and swim and say, okay, assume now for a moment that we have designed a liability regime according to the European or domestic rules, and that there is a liability of someone in the chain of AI, either a developer or an operator. And then, of course, the whole issue is, from an economic perspective, how do you design that liability? And what economists would normally say is that you need to balance what we call the positive and the negative externalities, in the sense that we say, well, AI may, and John was starting with mentioning that, have a lot of benefits, a lot of positive effects for society. We call that positive externalities. At the same time, and I think John was coming to say that, there may be negative effects for society as well. Damage can occur. There may be economic losses, property damage, personal injury, you name it. And of course, what is the key issue? You want, on the one hand, that society generates all these positive externalities and that we benefit from, let's say, all the advantages of AI. At the same time, we want to control the risks, the negative externalities. But then the key is, of course, how do you shape a liability system? And the same is true for a financial security model, in the sense that you don't kill the positive externalities at the same time. And so that is a little bit, let's say, the challenge for society. And now you also understand why we're looking at financial security, because it may be that some policymakers, like especially in the European Parliament, there are some people who are extremely nervous about everything that is called AI. And so they come with these revolutionary ideas on making insurance for AI compulsory. But then, of course, the question that you can ask, okay, how does that compare, let's say, to these positive externalities that we were talking about as well? Now, in order to answer that question, what I first would like to do with you is say, okay, you know, they talk about mandatory insurance. Let us for a moment broaden up things a little bit and not only talk about insurance, but talk about, I call it a bit broader, financial security, because we have a lot of ways in which we can get financial security, insurance being an excellent one, an important one, but definitely not the only one. Now, in a way, you already understand why someone may have a demand for financial security. And the answer is relatively simple. You know, if the result of that balancing of positive and negative externalities would be that we impose a liability on a developer or on an operator for the consequences of AI, it may be that the operator says, but I still want to generate all these positive externalities of AI, but I want to be protected under particular circumstances, and therefore I have a need, I have a demand for financial security. But let us focus a little bit more on when we say we have a demand for financial security, what we exactly mean with that. Why? Because basically, if we go back to the basics, and that's always a wise idea, even when you talk about AI, you have to say there are, in fact, two different systems of providing financial security. The first one is what we call a so-called first-party cover. What is a first-party cover? It is a model whereby I would, as an insured, for example, demand cover for the risk that I run myself. For example, I take insurance for my house. I take an insurance for my healthcare insurance. I take an accident insurance. All those are what we call first-party covers. The alternative is that you say, no, you are not covering for your own damage, but you are covering for the risk that you have to pay someone else. Why would you have to pay someone else? We already said it, because of liability. That liability cover we call a third-party cover. Now, in insurance theory, those differences are very important because there may be different demands for cover. Now, in the AI context, you can understand that relatively simply. Assume that we are in a beautiful Michelin restaurant, the one that Helmut and I like to visit and enjoy our life there. And there is the owner who uses a robot. And let's assume that the robot is serving the food and we are enjoying and we're looking at that. And it is Michelin star restaurant, expensive food. And of course, that robot is all AI. Now, what could happen? It could be that that robot is driving there and something goes wrong and all the food spills on the carpet. But we have two types of damage. We have damage on the carpet, but even worse, all that wonderful Michelin star food is lost. This is typically something that you would call first-party damage. But now we go to the situation where it's worse. Suppose that Helmut is sitting there, a very fancy gentleman, and he has a Giorgio Armani suit there. And now suppose that the robot comes there and spoils all the food over Helmut. And not only is his wonderful suit ruined, but at the same time, he may have some burning wounds on his hand or so. You understand, in that case, we're no longer in a first-party setting, but we are in a third-party liability setting. And now my question, do we need financial cover? Well, the two words an economist always gives as an answer when you ask him a question is, it depends. On what does it depend? Well, it depends on what we call risk aversion. Are you averse to those particular risks? On what does that depend? Well, that depends on the one hand, very simple, on the nature of the damage. What is the probability something goes wrong? And what is the scope of the damage, the magnitude when it goes wrong? Now, it may be if we take this first party cover, if you say, okay, you know, this carpet is very nasty. The fact that I lose the food is very nasty, but that is not an enormous quantity of damage. Moreover, I would compare as an owner the quantity of the damage to my own financial situation. And I would probably say, well, this is not something that's going to run me out of business. In other words, I would, in economic terms, not have an aversion against the risk of that first party damage occurring. But of course, you can change the number and then the story changes. Okay, now we turn to the situation of third party cover, liability cover. Remember, there was also a potential damage because there was a victim, Helmut, who was sitting in the restaurant with me. Suit is ruined and the hand may have burning wounds. Would there be, for that particular owner in that situation, a demand for cover? Well, we don't know. You know, it depends on the one hand, again, on the scope of the loss. We talk now about personal injury. That can be more expensive, depending on the nature of the injury, how long it takes to recover, etc. The suit can still be bearable, but okay. And so then again, it also depends on your own wealth situation. So what does it mean? It means we do not know for sure whether there will be a demand for financial cover, but it may be. And even more importantly, remember what Helmut taught me, insurance follows liability. In a sense, we only talk here about the demand for financial cover when that owner of the restaurant is liable for the damage that occurred. And that's, of course, why we first need to know a bit what is the liability context. It may be that, in fact, why did the robot spoil the food? Maybe because there was a mistake in the software that was developed. Could be a liability of the developer. And then maybe Helmut would be in a situation that he has to file a lawsuit against the developer. No liability of the owner of the restaurant. Or it may be that the owner of the restaurant did not listen carefully to the instructions provided by the developer. He did something wrong, and that's why the robot spilled the food. Yes, then there may be liability of that owner of the restaurant and of the robot, presumably then an operator. So you see, it's all very nuanced and it depends. But the general lesson, I think, for us now is very important. You cannot generally say that there will be with the individual a demand for financial security. It depends on the type of liability. Are you liable for that loss or not in a third-party context? And it also depends on what is the scope of the damage, how much is it, what is the probability, what is the magnitude, and at the same time, of course, also my personal wealth situation. Now, suppose for a moment that we have a demand for cover. What happens then? Then, of course, we look at traditional insurance theory applying, of course, to all the other types of financial security as well. What is that teaching us? Well, it is teaching us very simple that if an individual has a demand for cover because of risk aversion, then an insurance provider of financial coverage can give me satisfaction through a coverage. Why are they able to do it? Because they can bring together the risks in a pool and they can use the law of the large numbers. So what they will do, they will look statistically at the information on what is the likelihood that things go wrong, multiply it with the potential damage, and a nice premium will follow. And of course, we all know what is an important condition for all of this to go well, that we have information. Information that allows us to predict what is the likelihood that the things will go wrong. And for information, normally we need past loss experience. We need statistics. Now here with AI, the problem may be that we don't have that. So that may be one of the reasons why some insurers may call AI a difficult to insure risk. Generally with cyber, we see that at least in Europe, the appetite of insurers to cover this type of risk is not very large. So that may be one problem, that we have lacking information. You can then solve it with modeling. You don't necessarily need information on the past, but then you need to predict the future. which is also not that easy as well. So let's say in that sense, AI is definitely not the type of risk, like, for example, a fire insurance. Houses have burned since the Middle Ages. AI not. So the data that we normally need, we don't have. So that doesn't make it easy. That's the first problem. As a condition to provide financial security, we need information, we need predictability. Another one is that we need to control the classic problems in insurance of what we call moral hazard and adverse selection. And in order to do that, we need to differentiate risks. We need to bring them in small risk groups, and we need to know, for example, if we're going to cover, let's say, an operator, suppose that that operator would be liable, we need to be able to control the behavior of that operator with specific policy conditions. Again, that supposes that the insurance company or the insurance provider has information on the type of risk, and that the information may be lacking. So now you understand from the perspective of the individual, there may be various reasons why you would have, in case of risk aversion, a demand for financial security. Insurance is one of the ways that we can use to provide that, but whether there is such a demand depends. You cannot generally say that, depends on first or third party and on the scope of the loss. What about society's perspective? Are there now reasons to make insurance mandatory for AI as the European Parliament is proposing? The first thing, if you look at the document of the European Parliament, they are talking here about liability insurance. That's already striking. Why? I told you a minute ago that for AI, there may also be first-party cover. And there are lots of situations where in our countries, for example, in Switzerland, we have a lot of mandatory first-party cover for natural disasters, for flooding and other disasters. We have in Social Security, health insurance, also mandatory cover. So the fact that they only talk about liability is already striking. But then if you look at liability, why would you make that mandatory? Well, insurance theory says the only good reason to do that is when you fear that there is a risk of externalization. What does it mean? I could potentially cause a very large harm, and that harm would be higher than my individual wealth. If that is the case, there would be what we call under-deterrence. I would no longer be deterred from activities as a result of which I could throw the costs on society at large. And this is why, for example, one of the most important areas of compulsory liability insurance is liability insurance for motor vehicles, where we say there is a huge risk of insolvency. And here the insurance companies have an advantage. They can impose their obligations via the control of the moral hazard risk differentiation, and as a result of that, we get a better level of safety. Does it mean that there are strong arguments in favor of mandatory insurance for AI? I strongly doubt it, honestly, because as I told you a minute, the answer is technology specific. You cannot say generally, as the European Parliament just said in one sentence, we need mandatory insurance for liability for AI. No, that doesn't make any sense. You may have some small risks where there is not a lot of damage. You may have other risks. Sometimes there may be an insolvency risk, depends very much on the operator. So in other words, just to generally state that, that's not a very wise idea. Moreover, the literature also warns, be very careful with just introducing mandatory liability insurance if you don't know what you're doing. And let me be explicit. What does it mean? One of the things you need to know, is there a market willing to offer this liability insurance? And then you can already say, why do they only talk about mandatory liability insurance? Why not about mandatory financial security? Insurance is the most important one, sure, but there may be alternatives as well. You have to realize if you as a policymaker, you make something mandatory, which is not available in the market, then you may in fact stifle innovation, because then it means that the operators or the developers of AI would not be able to obtain cover, financial security cover, and then all the positive externalities, remember what I said in the beginning, could not be generated either. It is for all of those reasons that I have the impression, my dear Helmut, that the European Parliament is moving a little bit too quickly. And I think if I summarize, because I see I'm at minute 19, then I think that we should think this over a little bit more carefully. And that sometimes I have the impression that the European Parliament is, as you said it last time to me, Helmut, simply doing a policy of, I want to show that we do something about this risk, without carefully thinking over, is this really a serious problem? And is this really the way to address it? And I think for those reasons, that my general advice is, let us say to the European Parliament to really think before they act. That's all I have to say. Thank you.
Thank you very much. And notwithstanding that these are presentations independent of one another, I think that's a great reintroduction to John's discussion of the situation we actually have with cover. And I gather the echo problem has been resolved. And with that, I'll turn it back over to John, who I think has 15, 16 minutes left in his segment by my count, but I haven't been horribly rigorous about that.
Well, I hope I'm back. Can everybody hear me? And this is where I left off. Let's just say that what can possibly go wrong? Plenty with AI, and it's both physical and digital. And I think it's interesting that to pick up here with the compensation schemes. Thank you. I figured it out. Thank you. So there, I saw a text from Professor Abraham in there, and I wanted to give him a little plug for his fascinating article on proposing an insurance scheme or a rational compensation scheme for accidents from AI vehicles, autonomous vehicles. Kyle Logue has another one. There's fascinating proposals out there for rational solutions to the problem of compensating AI-related injuries. The RAND Corporation did a survey of stakeholders in the autonomous vehicle field, and their conclusion, asking whether essentially this question, can are Americans, or perhaps more accurately their representatives here in Washington, D.C., sufficiently civilized or rational to come up with a compensation scheme for AI and robotics? And the answer was almost universally, for this international audience, negative. And so that takes us back to existing frameworks of law. And so these range from the common law torts and contract theories that we American lawyers all studied as 1Ls, first-year law students, to more recent statutory regulatory regimes, some of which provide private causes of action for damages, most notably the Illinois Biometric Information Privacy Act, known as BIPA, where some fairly serious liabilities have been imposed, and there's been some coverage litigation relating to that, which I will provide a list of some of the cases. We may not have time to get to that. So-called little FTC acts, which are consumer protection laws that the states enact. Many of them provide private a right to private damages as well, and those have been used indeed against one of our clients pending. And here is the risk management conundrum, as I see it, with robotics and AI. And Professor FAURE alluded to this, that it is both first-party risk and third-party, so liability risk. And it's both financial or intangible and old-fashioned tangible physical damage, both first-party and third-party. And the lines between those risks and those harms are very difficult to discern at times. And so that brings me to the next topic of risk management. And this is a sort of checklist, I suppose, of what insureds involved with AI and robotics need to consider at the stage of underwriting their insurance or planning their enterprise risk management. And I will not go through every item, but I hope that these slides will serve as a reference later for those who want to review and recollect in tranquility, to quote Wordsworth. But the potentially applicable commercial insurance products for a robotics type product or system would range from what we call tech E&O, and that tends to be a liability only coverage, but there is also the more traditional general liability and property. And the tech E&O tends to cover non-tangible risks, as does the cyber specialty line. The more traditional property casualty products cover traditional hard damage, physical Newtonian damage. But what we need to be cognizant of here is the two but exceptions on both fronts, and that's the challenge in this area from a risk management standpoint. Here is I believe, an Aon chart showing the challenges of placing both E&O and cyber in this space. And here is a Aon chart that more graphically illustrates the disparity between traditional coverage of tangible risks, with which the insurance industry has always been much more comfortable and has much more experience with it, and a much broader basis for assessing the cost of risk. And on the right side, grossly underinsured, but from some perspectives, are the intangible assets with which insurance traditionally has been much less comfortable assuming the risk on that side. And so again, this, as any of you London Tube riders will understand, the challenge lies in these specialty lines, particularly for cyber and technology errors and omissions. The challenge is in dealing with the potential gaps in coverage, and not only between particular lines of coverage, but even within a single line of coverage, particularly a cyber policy, which tends to be composed of sort of modules, coverage grants that may or may not mesh cleanly. I will mention only the what I call other people's insurance as a risk management tool. Again, it's an important tool, but it's in my experience frequently fumbled in corporate America, at least. And in any event, protecting oneself with your vendors or your customers' insurance presents all the challenges of placing your own insurance without gaps and without unexpected coverage issues. And so here are the very broadly described some of the coverage issues that we either have seen or foresee. And I think, as I've alluded, the terms in current policy forms often just don't quite fit the risk. And this is natural. It's policy language has trouble keeping up with technology and changes in technology. Another issue that fascinates me from an intellectual perspective is most American policies have some sort of exclusion for so-called non-fortuitous loss, of course, and that is typically the expected or intended exclusion in general liability policies. But the inherent conundrum here is how does it apply where an artificially intelligent decision was responsible for the loss? And so there have been fascinating articles, law review articles addressing that point. But what I would like to talk about next is a trend that I see toward what I call cyber silos arising from the Silent Cyber Initiative. And that is so-called non-affirmative coverage. Here's a chart that shows how some of the traditional all-risk type insurance lines or policy forms can cover the intangible cyber risks that are come to the forefront, particularly in artificial intelligence and robotics. And so this shows potentially how traditional policy lines might cover it. And in response to that so-called silent cyber coverage, there has naturally been a concern from both the regulatory side and from the insurance industry side about unquantified risks that have not been taken into account in premium setting. And that's started with a regulatory initiative by the UK Prudential, the PRA, and it has been taken up by some of the American regulators and legislators. So it is a growing concern both among regulators and insurers that they don't, and this is of course natural, that they don't want to unintentionally cover unquantified cyber-related risks. The problem is that this presents insurers with two choices. One is to actually own that risk and to quantify it and affirmatively cover it. And the second is to evade it by adding cyber-related exclusions. And that's the easy way out. And that's, at least among our clients, that's the way out that their insurers have tended to take. And so we've seen some rather ham-fisted exclusions that actually exclude more than perhaps was intended, or that exclude traditional risks that any insured policyholder would reasonably expect. Now, there have been some there has been some market response to this problem of what I called cyber silos. Last month, there were a number of stories in the insurance trade press about Lockton launching a silent cyber property solution. I frankly have only found sort of articles about it. They don't really seem to have anything on the website. Marsh does have, has for a number of years had its so-called CyberCat forms, which are very interesting. And particularly, they offer a so-called silent cyber bridge extension, which is intended to, as I understand it, to drop down and fill in where exclusions, including these new exclusions resulting from the Silent Cyber Initiative, have created gaps. And so this is how they graphically depict their solution, with the CyberCat form in the middle, uniting all these, or at least filling the gaps between all these other policy lines. And that silent cyber bridge, this is from their website, the optional bridge is the key here that would fill those seams. Unfortunately, the insurance market take up for that has been very minimal. But I think it is an ingenious and increasingly essential insurance solution in a world where the lines between the physical and the digital are increasingly hard to see, or at least increasingly debatable. I think I will simply leave to you these collections of some illustrative coverage litigation, including litigation over the use of AI, or at least algorithms, in evaluating claims. If you're interested in that sector, I would recommend this Green v. Geico case, fairly recent, out of a Delaware trial court. It's pour a pot of coffee first. It's 163 footnotes, but it's an excellent introduction and background on AI. The decision really didn't reach a decision, but it's a great exposition. So I will end it there. I'm happy to answer questions if there's time at the end, and the slides will be available for further study.
Thanks, John. I think Christoph will introduce Professor Schwentowski now.
Yes, I'm afraid there's not much time for questions, so we just continue. Well, thanks, John. You were saying that it is rather unlikely that the U.S. administration will pass any legislation on compensation schemes. So our next presentation, which is on compensation models, might hopefully still be interesting for you. So I'll wait.
Europeans are more civilized than Americans.
So, ladies and gentlemen, I have the privilege to introduce Hans-Peter Schwentowski to you, who is one of the best-known insurance lawyers in Germany, and who is an academic who teaches or taught law at the Humboldt University in Berlin. He's sitting right next to me, as you all can see, and he's going to address the new compensation model, new perspectives for liability of robots and AI. And I think what we need now, Oliver, is the slide deck. So if you could make that available. And there we are. Do we have control yet? Okay. Wir können den Bildschirm steuern, sagt er uns jetzt. Okay, it's right there, maybe. Doesn't work yet. Oliver, what do I have to do?
Oliver, you're muted, and maybe you keep on turning the pages for.
Okay. Okay, so to tell him next slide, please, and he's going to continue.
Hello,
okay.
Oliver.
The floor is yours.
Yes, thank you very much. Good evening, ladies and gentlemen. Good evening in Europe, and I believe good morning or good day in the United States of America and Canada. And welcome from Berlin. And thank you very much that you give me the opportunity to discuss with you about perhaps a new compensation model and new perspectives for liability of robots and AI. The next slide. Oh yes, I believe Professor FAURE, he mentioned this resolution of the European Parliament from February 2017 sometimes, and it's correct. The European Parliament means we should give a definition about the legal status of robots on the long run. And perhaps they discussed robots shall gain a status as electronic person like a legal entity. And okay, hence the robots creating legal liability for cause damages, and that means legal liability should regardless of negligence or fault. The next slide, please. Next slide, yes. The key questions in my eyes, robots are approximated to the human being as a legal person. You all know that. And my question, and I believe that's a question in the United States as well, and my Professor FAURE has the same question: does this make sense? Or does this legal construct take it perhaps too far? My question is, should the system of liability be replaced by another model? That's a model I call a compensation model. And the next slide is necessary. Let's have a look to the traditional systems of liability. According to traditional systems of liability, it is the human, we, all of us, we are controlling cars, railways, or ships, or aeroplanes, or software, or self-learning machines. We know that. As we, the human, controls the machine, she, he, or they, we are all of us, we are liable for any damages caused. Okay. The reason is human being is to change behavior due to the threat of liability. Is that the same to robots? Actions of robots are really not controlled by consciousness or will. Perhaps that will change in the future, but I do not believe that. But that is not the question in this moment. Robots are based on an algorithm, a self-learning system, and a manning software. The robot is ready to retrain at any time. That is different to humans, you all know that. If only needs an impulse, and I believe that is only an electric impulse to do so. Why, ladies and gentlemen, do we need a system of liability for robots, even though they do not act consciously or will control? Let's have a look to an example, the case of ThyssenKrupp, and that case will really happened some months ago here in Germany. ThyssenKrupp has a supply contract for car parts with Volkswagen. Someday, a truck with parts arrives at the Volkswagen factory in Wolfsburg. And the workers have a look to the parts, but they are really astonished the parts do not fit. And the workers for Volkswagen asks why ThyssenKrupp is delivering these parts. And ThyssenKrupp replies, oh, we do not know that. Our software cloud made that decision. And ladies and gentlemen, it will never be detected who caused the mistake in the cloud till today. And the question to me was, who is liable? Volkswagen? I do not believe. ThyssenKrupp? It's difficult. The cloud? But you all know the cloud is not a legal entity. The cloud is in the world. And experts told me it's really impossible to detect such mistakes in the cloud. And so we can learn from this case that a system of liability of robots couldn't help to solve our problems when we are working with the software cloud. And I think that will be normally in our future. Yes, what's to do? Perhaps, ladies and gentlemen, we should have a look to the principles of our health insurance system. I believe that is the insurance system in Germany and Europe, but it's really the same, I believe, in the United States as well. It's not really important to know if that is a mandatory system or a private system. In health insurance, we also do not ask who caused or is liable for the disease. Instead, the costs for the cure are reimbursed for all of us. I believe it's a very good idea to have that system in the corona crisis. And we have only some exceptions, and that means cases of intent. And my question is, why do we apply the compensation model in health insurance, but not in self-learning AI systems or robots? Or is that the wrong question? And when we have a look to other countries, we will see they have the compensation model already practiced just in the moment in road traffic as well. That means New Zealand, in some parts Canada, Australia, and Sweden. The question for all of us, I believe, is would it make sense to use the compensation model for the principal compensation of damage caused by robots and self-learning and AI, and including really important cyber risks for the future? Do we have advantages when we change to a system which called compensating systems? People need robotics. I believe we all think so. And we need artificial intelligence in the future that makes our life easier and increases prosperity. Robots, that is clear, are not people. It makes really, in my eyes, no sense to hold them liable. They are not undertaking this well. Damage caused by robots should be, in my eyes, compensated. In order to incentivize robotics, we need robotics. We believe that is our future. At the same time, the software, if you make mistakes, should be updated and improved so that no further damage occurs. We hope that, yes. But ladies and gentlemen, we have more advantages. According to Hans Werner Sinn, he's one of the most important and greatest economics in Germany in the last decades, a compensation model promotes prosperity because, that is his thesis in his habilitation in 1987, people are willing to take new risks and undertakings as well if general risks, for example, damage caused by robots, are covered. In this sense, risk is a prosperity enhancing production factor. That is the thesis from Hans Werner Sinn. A production factor means the same factor than capital or working. The same applies to the insurance principle, which distributes risks over many shoulders and transforms them in this way. That is Professor Ulrich Meyer, University Bamberg. When this thesis is correct, we should have a look to a very important question, and that is a cost of a compensation model like this. First, the compensation model dispenses with the question who caused or is responsible for damage. Instead, all damages are compensated. Yes, ladies and gentlemen, and that is really a very, very important question. Isn't that far too expensive or not? Some ideas to this question. The first is, I believe we need an, yes, but we haven't, yes, that is the right slide. Thank you very much. Currently, ladies and gentlemen, the damages of the injured party are borne by insurance companies. You all know that. And when it comes to robots, this is how it should also be done according to the European Parliament. Okay. In fact, the damages of the damaging party must, in my eyes, also be compensated, and these damages are currently borne by the damaging parties themselves. We all know that. Either they have financial reserves, we have financial reserves, or they or we go bankrupt. And you know, if you go bankrupt, so that is a public problem. The public bears the damages. The public are we all. We bear the damages. If that is correct, ladies and gentlemen, the compensation model, therefore, does not create any new costs, but merely distributes the costs between all parties with a good system right from the beginning. Yes, there is no longer any differentiation between the damaging party and the injured party. The compensation model, you see, works in the same way as our health insurance system, in the same way. As a result, society does not incur additional costs, but, and that is, in my eyes, a very good message, tends to reduce costs by minimizing risks. And in this way, prosperity for all of us increases. Instead of liability for robotics, ladies and gentlemen, what do you mean? Should we practice the compensation model and compensate all damages caused by robotics and AI, exception, the machines are intentionally controlled to abuse the system? Is that the right way, the new way, the way for the future? I know, yes, ladies and gentlemen, that is a very great and very big question, and we have to solve a lot of detailed problems when we go this way. But the first question and the first step is to decide if we should go this way for a good new future or not. Thank you for your attention.
Okay, thank you very much, Professor Schwentowski. It is now my privilege to introduce to you a leading expert in the field of cyber war and cyber terrorism insurance, Mr. FRANZ GROMOTKA of Munich Re. I apologize for not being able to do justice to his CV in a short introduction, so I'll just mention a few things. He is qualified to practice law as an attorney and as well as a corporate legal counsel. He held the following positions within Munich Re. He was an underwriter for third-party liability risks in the Netherlands and Belgium. He has been a corporate underwriter and a legal consultant in a corporate underwriting legal and distribution department within Munich Re, and is currently a senior corporate underwriter, cyber, and a legal consultant, and focuses on legal developments in the context of cyber insurance and cyber reinsurance. As a member of the Geneva Association Cyber Terrorism and Cyber War Task Force. He is one of the minds behind the Geneva Association Cyber War and Terrorism Report and the Cyber Attribution Consensus Report. Ladies and gentlemen, Mr. FRANZ, GROMOTKA.
Thank you very much, Dr. William. Dear colleagues, many thanks. Hello and good evening to the audience. And I really like to thank you for the opportunity to present some of the challenges cyber reinsurance and insurance faces currently when it comes to cyber war and cyber terrorism exposures. In progressing with my presentation, I would refer solely to cyber war, but I mean all cyber war, cyber terrorism exposures. Please allow me also already here at this point that I will put my focus on the particularities and special features of cyber insurance and reinsurance. So, perhaps one slide. Cyber is one of Munich Re's main strategic areas, and we invested significantly from the very beginning of this quite new field of insurance into building up know-how and expertise, internal processes, networks, and of course underwriting guidelines in order to manage cyber risks. While it must be the aim for every insurer to support its client as far as possible by providing coverage, there are definitely limits, at the latest when the balance sheets comes at risk. It is up to the industry as a whole to define, in the context of cyber insurance, what would be cyber war and cyber terror exposure that poses a systemic risk that has the potential to cripple the cyber insurance marketplace as we see today due to its enormous accumulation potential and its unpredictability. There are already considerations in a very early stage how to handle such systemic cyber exposure through pool solutions or governmental backstops, for example. However, it is far too early to talk about how such solutions could look like. I would like to start my presentation now with a short recap on the basics of cyber insurance, and here I have to thank the speakers before me, Professor Buchanan and Professor FAURE, as they already pointed out that we have first-party and third-party exposure, and cyber is kind of a hybrid as it encompasses both. I would follow then with a short description on the NotPetya attack in 2017 and why this had a particular influence on cyber insurance and why we are talking about cyber war and cyber terror as much since then. And then I will follow and outline some challenges the industry faces when it comes to address and limit cyber war and cyber terrorism exposure. Please feel free to ask questions. I try to answer them in the course of my presentation. Before I go into details, let me very briefly recapitulate why we have a unique situation in cyber insurance in this respect. When it all started, cyber insurance was predominantly an insurance against privacy and data breach liability, covering solely financial losses of the insured, such as notification costs, for example, or damages for victims of a data breach. Therefore, a war exclusion was not deemed very necessary due to the absence of property damage, bodily injury, and death exposure. But as technology evolved and also the rapid changes in the IT landscape, and unfortunately the accompanying threats, today almost all commercial cyber insurance offerings contain first-party coverage elements also, as in property insurance. Such, for example, as replacement costs for hardware, if such hardware cannot be restored, or a very prominent component in this respect is cover for losses due to business interruption of the insured, if the insured's business is down to an insured event like a cyber attack. Coverage can go so far that in the event a service provided to the insured is interrupted due to a cyber incident in the sphere of the service provider, and this is leading to a business interruption at the insured, cyber insurance will respond with so-called contingent business interruption coverage if offered. While third-party exposure such as data breach might of course create large losses, it is not seen critically as it can be modeled and is therefore unsystemic, so to say. Of course, as also Professor FAURE mentioned, we do not have the data from past losses, so we need to predict it, but we think data breach is modelable. First-party exposure and especially business interruption and contingent business interruption, however, are risks of potential systemic nature, as they have a very high potential for accumulation. There's agreement in cyber reinsurance, for example, that such exposure is not insurable if triggered by the failure of electricity or internet, for example. So-called critical infrastructure failure exclusions are therefore already a market standard in cyber insurance. The fast growth of cyber reinsurance in recent years, cyber insurance and reinsurance in recent years is therefore only the other side of the coin of ever-growing exposure, making cyber risk the most pertinent and certainly one of the most contentious threats at present in insurance and reinsurance. Interdependent supply chains and globally correlated risks can lead to enormous accumulation losses for the entire insurance industry, a lesson painfully learned during the pandemic. Now imagine COVID-19 would not be a biological but a computer virus with similar potential. Imagine further the virus was brought by a group of malicious actors with the intent to inflict maximum harm to society. And now I want to give some details on NotPetya. One could easily describe NotPetya, an up to this date unique cyber attack that wreaked havoc around the world in June 2017, was the wake-up call for the industry as it pointed to the direction what disastrous potential an alleged state-sponsored cyber attack could have. When the NotPetya malware had initially broke out, victims had immediately assumed it was a normal criminal ransomware like the WannaCry attack a few years earlier, because they were presented with a note on their computers stating that their files have been encrypted and that they must pay $300 in Bitcoin in order to decrypt their files. The outbreak started in the Ukraine when a tax filing software, which is used by a large number of businesses in the Ukraine, received infectious updates. The attackers were believed to have hacked into the software company's servers that hosted the updates and embedded malware into these updates. And now when organizations using the software received the updates and installed them, they ended up installing NotPetya as well. Some of the countries affected by NotPetya were besides the Ukraine, Russia, Germany, France, but also United Kingdom, Norway, Denmark, and the United States. The outcome of the outbreak resulted in immense financial losses for over 2,000 organizations, some being large multinational organizations, the vast majority of damage due to business interruption, as the companies were no longer able to access their computer systems. There were some controversial details regarding NotPetya and its true intentions. There are strong hints that the threat actor behind NotPetya may be a Russian advanced persistent threat group that is at least tolerated by Russian authorities, if not even actively sponsored. But these are speculations. Another detail that points in this direction is the fact that the attack took place at the height of the conflict over Crimea between Russia and the Ukraine. It further turned out that NotPetya was not ransomware, but a so-called wiper, which has the sole intent to permanently block access to the operating system of the infected computer, making it unusable. This would be an outcome that is not very common for criminal actors looking for revenue. In the aftermath of the NotPetya attack, affected companies approached their insurance companies to obtain compensation for the damage. As business interruption is a component of both commercial property insurance and cyber insurance, many insureds expected both policies to respond. While cyber standalone insurers paid claims out in full, some property insurers initially rejected the claims since no physical damage had occurred in the first place, which is a precondition for property coverage known as the so-called physical damage proviso. Some of these disputes got quite some attention in the IT security and cyber insurance community, but also in the public. Due to their ambiguous policy wordings with regards to the physical damage proviso, some of the property insurers then invoked the war exclusions in the property policies on the grounds that the losses occurred in the course of warlike actions between Russia and the Ukraine. A prominent case in this respect is Mondelez versus Zurich Insurance, Proceedings are still ongoing, the outcome is unclear, and the burden of proof in this respect lies with the insurers. So we need to see how that turns out. I don't want to get into more details for now with regards to cyber exposure in traditional lines of business, maybe better known as silent cyber, but concentrate on standalone cyber insurance because the NotPetya, as an alleged hostile state-sponsored cyber attack, had profound implication on cyber insurance. As mentioned before, when cyber insurance evolved, little emphasis was put on war exclusions, and when coverage shifted to more first-party loss exposure, insurers incorporated traditional war, I call it traditional war exclusions, into cyber policies that are used in other lines of business, for example, property insurance. This was in part also due to the fact that regulatory bodies in some markets made it mandatory for cyber insurers to incorporate war exclusions in their policies, for example, Lloyd's of London. On this slide, I want to show you one example of a traditional war exclusion. The language highlighted should demonstrate the fact that such traditional war exclusions are not really fit for purpose for cyber reinsurance or insurance, as they simply do not address the fact and circumstances needed to also exclude hostile state-sponsored cyber operations which bear a potential unmanageable accumulation risk. There's agreement on the key points. On the one hand, war risks are generally not insurable due to their systemic nature. This compromises hostile cyber operations in the course of a war between nation states, of course. On the other side of the spectrum, cyber attacks that have a purely criminal intent, such as ransomware, are the very reason for companies to take up cyber insurance in the first place. Up to date, there is not really alignment in the insurance and reinsurance industry on a common understanding what should be covered and what not when it comes to hostile state-sponsored cyber operations and a possible need for exclusions from coverage as they have unmanageable accumulation exposure. Between those, so to say, cornerstones, malicious cyber act and war on the other hand, the picture is blurring. How to define warlike operations? Another example is the use of the phrase kinetic war in cyber exclusions. Numerous near misses might serve as an example here. While in most cases there's obviously no evidence that the attack was carried out by or on behalf of a nation state, there's definitely the possibility of a catastrophic state-sponsored cyber attack which does not include physical operations or that leads to the outbreak of an open conflict between two nation states. In this context, it might be noted that the exclusion of declared war only misses the point completely, as almost all warlike conflicts in recent times were not formally declared by one of the belligerent parties. Another very particularity in the cyber context is the challenge of attributing an attack or an operation to a specific state. While in an open physical conflict, this is relatively easy to objectify, it can be observed that nation states strategically try to keep their cyber abilities utmost secret. Almost all countries maintain cyber units within their armed forces, like the US Cyber Command, for example. But little to nothing is publicly known about their tasks and what their approach would be in a potential conflict. There are no cyber maneuvers. One can certainly presume that these units are very active in research and development of potentially destructive virtual instruments. However, NotPetya remains the only cyber attack that allegedly was carried out in the course of an otherwise physical conflict between two nation states up to date. And even in this case, formal attribution has not taken place yet by an appointed body, such as the European Union or the United Nations Security Council. The before mentioned attribution problem applies in particular to cyber operations carried out by or on behalf of a nation state. This might be different in cases of cyber terrorism, as a primary motivation of terrorists is to show their capabilities and intimidate the public. Another point in this respect would be that terrorist actors might want to create as much chaos and damage as possible, if their action is not targeted to at an individual person, like a kidnapping. In this context, it was discussed as an example that a potential target of a terrorist group could be the manipulation of the electronic control system of the slices of a major dam via a cyber attack leading to widespread flooding of a densely populated area. This would most probably create enormous damage, resulting in numerous people dead or injured and additional large property damage. Of course, there are numerous other scenarios possible, and the growing use of and simultaneous dependency on operational control devices or smart devices allow possible threats to become more likely. I want to consider that in such a context, I would describe cyber as the peril, the modus operandi, how the terrorists carried out the attack. The ever-changing dynamics and progress in the IT landscape and the interconnectedness in the virtual world, which of course includes new technologies such as quantum computing or artificial intelligence as well, might make scenarios more likely that terrorist threat actors use virtual means rather than bombs and explosives. It still needs to be seen whether terrorist groups go in this direction and build up capabilities. In any way, these developments are closely monitored by associations designated to ensure against terrorism, such as Extremus in Germany, FAURE in the UK, and TRIPRA in the United States. However, apart from the human suffering, for standalone cyber reinsurance, such events would perhaps have a limited impact due to the coverage of pure financial losses only. In this context, the so-called cyber terrorism carveback, a re-inclusion of defined terrorist activities in cyber war exclusions, is ambiguous and might have little practical use when tested in a dispute between an insured and an insurer. But this is my personal opinion. However, there is still put much emphasis on this feature, especially by brokers. One could assume that it is seen as a broad way to open up for otherwise excluded coverage by the traditional war exclusion. In between cyber war and cyber terrorism, I would locate hostile cyber operations carried out or at least supported by a nation state that may have a detrimental and disruptive impact on the functioning of another state. One would assume that if the impact is big enough to the attacked state would respond, which then would lead to an open conflict between the attacked state and the attacker. When this will happen is the existential question for reinsurance and the insurance industry, as the industry cannot retreat to an "we know it when we see it" approach. This brings me to my last aspect I want to highlight here, the potential systemic risk of cyber war coverage. This is an important aspect, especially for reinsurers, due to the hardly quantifiable accumulation potential. A severe attack could lead to the disruption of essential services or infrastructure and interrupt global supply chains. Again, NotPetya might serve as an example. Once out in the open, a cyber attack would most probably not stay local but spread globally, leading to enormous collateral damages worldwide, another aspect that needs to be taken into account when trying to model such scenarios. While the industry has shown after NotPetya that it can absorb such cyber attacks and also might be willing and able to cope with even bigger events, the challenge for reinsurers especially lies in the capabilities to develop robust models. It is not tested yet, but a kind of rocking up of retaliatory cyber attacks between two nation states below the threshold of an open outbreak of a war would probably pose a ruin scenario for the insurance industry, which needs to be excluded. If you take a look at the graph, one would locate the boundary of insurability somewhere between a hostile state-sponsored cyber operation, in this case called HCA, and cyber war. To define this exactly is the challenge for every market player, depending on its risk management framework, its risk appetite, and may be also influenced, of course, by regulatory requirements. To summarize my thoughts, I would like to emphasize that the position of the reinsurance and insurance industry on cyber risk must be to prevent uncontrollable accumulation risk that has a ruin potential, and at the same time consider the interests of the insured being sufficiently protected against any cyber attack, and furthermore not to jeopardize the cyber insurance value proposition by taking a too strict or an ambiguous approach. This can be achieved by a cyber war exclusion that adequately addresses the dimensions, common language, the possibility to attribute attacks to nation states, and the impact of hostile cyber operations short of cyber war. At present, there are various initiatives in the markets, for example, driven by market associations and single insurers to tackle these challenges. Munich Re, as a global reinsurer and active market player in cyber insurance, is heavily engaged and in constant dialogue with all stakeholders in order to keep the momentum and reach a sustainable solution for the cyber insurance marketplace, which is needed if we further want to support the highly dynamic progress in virtual technology through insurance offerings. Thank you very much.
Thank you very much, Mr. GROMOTKA, for this extremely graphic description of the terrorism risk associated with in the cyber context, and especially with artificial intelligence. We truly appreciated your presentation, just like all other presentations that dealt with AI risks and insurance from different angles, from different perspectives. And I think overall that concludes and gives us a very quite comprehensive picture on what the situation is and what the challenges are. That is probably what we heard most in these lectures, that there are challenges, in fact, risks that you described, Mr. GROMOTKA, but also challenges for the law, be it the contracts to be concluded and drafted, but also the acts of the legislator to be expected, liability models, liability insurance models, compensation models. There's a real competition of ideas right now out there, and it will not be easy to decide which way to go. And maybe there's not only just one answer, maybe there's different answers to different situations. We will see that in the future. Let me thank you at that point to all lecturers who have contributed and made this such a valuable event. And let me also mention and give thanks to all the participants. It was great to have you. It's easy to explain what would be a speaker without an auditorium. So without you, that would not be possible. If you want to review what we have done here, I would like to mention that all the lectures and the presentations will be uploaded at the website of the European Law Institute's Special Interest Group on Insurance Law. We will notify you once this is done, and we will also give you the link to the website so that you can enjoy once more our event. Let me finally mention that we would, of course, love to see you again in our third semester of ATILA lectures that we will open in spring 2022. We have chosen for the next two lectures the overall topic of automobile insurance problems and policies, a transnational comparison. That may sound like a more traditional, more conservative topic as compared to COVID-19 issues or artificial intelligence issues that we have dealt with so far. But in fact, if you look closer into automobile insurance, there is many very current issues. There is many differences still in the system. So if you deal with it on a comparative basis, as we will do, and certainly there is very challenging issues when it comes to transnational situations of traffic accidents and compensation of traffic victims. In this sense, we would all hope to see you again in spring 2022. The lectures will take place on 10th of March and on 19th of May, as is already displayed in the invitation to today's ATILA lecture. That gives me the opportunity to wish you a happy end of this year and a very good holiday season, and give you a good farewell and the wish to see you again in good health next year. Thanks, everybody.